Okay, so I just wanted to welcome Michael along to today's session, and we'll be talking about Michael's experience of studying at the Sydney Law School and experience of university and studying law. So, Michael, many thanks for your time today.
It's always a privilege to take part in the life of the Victoria Law School, and I'm very grateful that Professor Clark has invited me to talk to a group of students at that law school. And necessarily, I must start by acknowledging the Indigenous people of our country, the First Nations people, as we're now learning to call them, who were neglected, grossly neglected, never mentioned when I was at law school. And I never put up my hand to ask questions about the injustices that existed then. On the day that this session is being recorded, I attended the farewell to Chief Justice Bathurst, Chief Justice of New South Wales. Shortly, he will be replaced by Chief Justice Andrew Bell. And he has been Chief Justice for 10 years. And at the beginning of the whole ceremony, with the Banco Court awash with judges in their long full bottom wigs and QCs and SCs similarly attired, and many members of the community and many people in the law, the welcome to country was the beginning of the ceremony. And that is something we've copied from New Zealand, which was always much better in its treatment of its Indigenous people, largely because they were more numerous, about 17% of the population, and they were more warlike than our Indigenous people. And it was a wonderful welcome to country, highly intelligent, and it's therefore something that it's appropriate to mention. That did not exist when I was at law school, and it didn't exist when I was, for most of my legal practice. It's something that came along in the early period of this century, and it's something that's appropriate to mention when I contrast my days as a law student with my days in the period since I left the High Court of Australia in 2009. Very different worlds, and it's important for students to derive from my experience an important lesson. And that lesson carries over into study, but also into classrooms and also into legal practice. The lesson is to be a questioner, to take an important role of testing propositions, not just to accept propositions that are laid down by teachers or by textbooks, but questioning propositions and asking uncomfortable questions, such as why are the Indigenous people not recognised in our law? Why do we not recognise their right to their traditional lands? Why are women subjected to injustice and inequality in the law? Why are people from other lands and cultures with different skin colours and appearance treated so differently in Australia in the age of the White Australia policy? That was certainly the case. And why are LGBTIQ people criminalised and locked up because of their sexual orientation or gender identity? Many other groups could be referred to, but law is not an ordinary job. Law is about the control of power. Lawyers have a very important role in upholding the rule of law, but doing so in a milieu where they ask questions and are constantly testing the fairness, the justice and conformity with universal human rights of the legal system. One of the people who was present at the ceremony that I attended this day was the Honourable Murray Gleeson. Murray Gleeson was a young man who had gone to St. Joseph's College, and I had gone to Fort Street Boys High School, which is the longest existing public high school and school in Australia, 1849. And we met at the steps of the Stephen Roberts Theatre in Sydney, at the University of Sydney. We were both doing the arts law course, and our work threw us together. The first proposition that we should share our study came from Murray Gleeson. He was always a very intelligent man, and he looked up the leaving certificate results, and he found that I had done marginally, well, significantly better than he had, with top of the state in history and top of the state in general mathematics. And he thought, I can get this workhorse to share the study, and we will discuss that. And so when we got to law school from the arts faculty, where we were doing the abbreviated arts law course, he approached me and said, now look here, we're stuck in this place for the next 4 years. We should share the taking of lectures, the writing up of lectures, the preparation of summaries of the lectures, and the communication about the issues in our course, which can help us to absorb a huge amount of information that we were receiving from our law lecturers. In those days, the class, which numbered about 100, was overwhelmingly male. I think there were only about 5 women in our class in Law 1 in the year 1957. And that class had the obligation of learning a whole lot of matter off by heart. That was the way it was done in those days. There were no books that you could take into exams. You just had to have all this material cram-packed into your brain. And that was really what gave a premium to good memory, which both Murray Gleeson and I had, but it also made it useful to share the taking of lecture notes, because both of us, after the first year of law, were working in a legal firm as an article clerk, and therefore occasions would arise where we would have to miss lectures because we were in court or we had something else urgent for our master solicitor. And so that was what we did. And we would divide up the world. I still think that he was a bit weak in federal constitutional law, because that was a subject that I claimed for myself. And if anything, I would be a little bit weak in the subject of company law, corporations law, because that was a subject that he was very interested in, and he claimed that for himself. And so if you would like to know the division of the spoils, a Pope's line was crafted between the subjects that I took responsibility for and the subject that Murray Gleeson took responsibility for, you will then get a clue as to the areas that we liked and the areas that we were good in, because you tend to be good if you like the subject and if you're interested and have a passion for it. Passion might overstate the feelings of a law student about a subject in a law school, but certainly sufficient interest so that you could pack the information away in your mind for that awful day when you had to sit in the Great Hall of the University of Sydney and write out your examination scripts. Murray Gleeson has a very neat handwriting. I think he was taught that by the brothers at St. Joseph College in Sydney. I have an even better handwriting. Mine is a copperplate handwriting that was the product of the inkwells and the slope cards and the other mechanisms of neat script writing that I learned at the public schools that I attended. And so within a week of a matter being lectured upon, we would exchange on paper of similar size with 3 punch holes in it and put into binders the summaries of the matters that had been dealt with in the lectures during the previous week. And necessarily, because these were topics that we had severally chosen to concentrate on, the extra mile was gone in the writing out of the lecture notes. Cases that hadn't even been mentioned by the law lecturer were extracted from law books, from case books, and from the other textbooks that we had, and from the law school notes, which were cycler-styled notes that we received from Mrs. Gaunson, who with her little puppy dog had a special office in the Sydney Law School, and whose duty it was to hand out to all the students the law school notes, which were used by the lecturers to give their lectures to the students. And that was the way the foundations of our understanding of law really began, because neither of us had a father or other relatives who were practitioners of the law, and therefore it all came to us as a something of a surprise and something of a mystery. But we knew we just had to write out the lecture, add the extra mile of the notes that we'd looked up, give short summaries of the critical cases that had been mentioned by the lecturer and of the facts and holdings of those cases, extract the holding of the case, that is to say, the rule for which the case stood, and extract that from the judges in the majority in the case, and do that with efficiency and speed. And that taught both of us to be quite efficient in the work we had to do. When later we became judges, and in Murray Gleeson's case, Chief Justice of New South Wales and Chief Justice of the High Court of Australia, he was always very quick in getting his reasons in. And likewise, I was always very quick because I'd had a training in this back at the Sydney Law School. Nothing is worse than a judge, especially an appellate judge, who's holding up the whole court because either he or she is undecided or indecisive, worse still, or is doing other things like going to concerts, going to the theatre, or doing other civilized things. We learned at law school that that was not for us. For us was perspiration, not so much inspiration, perspiration, getting the matters for our study into our minds. There was one aspect of my notes which was different from the notes of Murray Gleeson, and I shared this with him. And these were the summaries that I did based upon the notes that I either did myself or was receiving from Murray Gleeson. We never shared the effort with anyone else. We didn't look for another slave who could do our work. We knew that by writing out the summaries and the lectures, that was a way to get things into our head. I'm sorry to say this, and it may have changed in the age of computers and typeface and all the other mechanisms that are available today. But for me, it was always a way of learning to write, and to write things out in a conceptual way, in a neat summary way. And then I would take one extra step, which is one that I commend to those who are watching this program. The extra step was that I would prepare a note, generally on 1 or 2 pages of the note paper that was going faithfully into the binders, of a tree diagram, which was a summary of the summary. And the advantage of the tree diagram was that it laid emphasis upon the main concepts that would be contained in summaries of the lectures that would go over 10 pages. I would have a 1-page summary in the form of a tree diagram. And the tree diagram, I've seen that there are textbooks in law where other publishers have purloined my technique, and they actually sell their textbooks in the form of tree diagrams. Maybe you've seen them. Maybe they've also gone out of vogue because of computers and the modern means of communication. But the summary of the summary in the form of the T diagram tree showed the grand concept on the left-hand side of the page, the sub-concepts then down the page, the sub-concepts then scattered as appropriate to the main concepts, and the notes, very, very super short notes on the chief cases or statutes that were relevant to the matter in hand. Those days, that is to say the 1950s, 1960s and 1970s, were days of the common law. Most of our lectures were devoted to learning what courts had said was the law. There were federal, state and local legislative measures. They were important, but the common law was in those days the center and core of what you had to learn as a young lawyer. And therefore you'll make an adjustment for what I'm saying on this occasion by the big shift to statutory law that has occurred during my lifetime. But the idea is still valid. You've got to understand the big themes. You've got to see detail in the context of the big themes. You've got to be able to arrange your thinking in a way that doesn't lose the big themes, but fleshes them out with the little themes and the illustrations. That was something I had actually started when I was at school. And I did very well at school. So I thought this is a very good technique, and I'm going to continue it for my own benefit. And being a very generous spirit, I shared it with Murray Gleeson, who actually did better at the law school than I did, something that I've always harbored a grievance about, given that I had prepared the most helpful notes that I shared with him, even to my copyrighted tree diagrams. I would share those with him, and then they would become the basis of my studying for the exams. And when I had forgotten a lot of the detail, I could still go back to my notes and see the grand concepts and how the grand concept of the law, say companies law, or say federal constitutional law, I could see the grand themes, and then I could look to the right of the page and see the sub-grand, the sub-grand, and the minor themes. So that's what you have to do in the law. If you do that, you will never lose your bearing in relation to answering a problem in an exam, because you'll always be able to take your mind back to the grand themes and just work out how you fit the problem into those grand themes. I became rather cunning in my latter part of my law school lectures. This was before I did the Master of Laws course and the Bachelor of Economics course, which I did after I finished my Bachelor of Laws degree. When I did an exam transcript, and in those days we would do it in handwriting. In my case, copperplate handwriting. In Murray Gleeson's, very clear handwriting taught to him by the brothers. But when I came to answer a question, I would first of all analyze the question in the exam paper. And I would then start making notes for the answering of the question, originally on the blotting paper, which we had in order to blot the ink that came from our fountain pens or from an inkwell and a pen. I would jot down the notes in the form of a tree diagram. And I then came to the view in my second year of sharing this technique with Murray Gleeson. Why should I deprive the examiner of seeing my summary in the form of notes? Won't that be helpful to the examiner to see that I have covered all the bases that are essential? And won't that be a good thing to do, seeing as I would throw it away? Why not share it with the examiner? And so by about the second year of my law course, I then started on the obverse page of my examination transcript to write out the tree diagram for the answer to the question. And when I did that and inflicted on the examiners my technique, not only did my marks go up, but it became something of a pleasure because I could share something I had learned in school days or taught myself in school days with the examiners in question, very discerning people. And Murray Gleeson didn't have that technique, but he still did better than I did in the law course. But it was something that led to my reaching a point in my law school days, which I'm almost embarrassed to mention now, which was that I ended up enjoying doing law school exams. It sounds a bit weird, and given the other more exciting and interesting things that one can do at the age of 20 or 21, it is a bit weird. But I got to the point that I enjoyed doing it. I then started to put headings in my exam questions, and I started to use colour of ballpoint pens. What a show-off I was as I look back on my exam scripts. But they were trying to show to the examiner that I was not just stumbling from one case to another or from one matter of detail to another, but that I had got into my head the big themes, the grand themes relevant to the particular case or the particular problem in hand. And when you start enjoying exams, it not only leads on to hanging on to your university days and doing more degrees after you've finished your BA-LLB, it also leads to your enjoying what is otherwise a rather arduous activity, and that is cramming things into your head and then putting it down on paper in answer to a particular question. Looking back on it, I would have to say that that technique of teaching law in large lecture halls with 100 students from the year listening to every word of the lecturer, very few questions asked, certainly none interrogating the justice, morality, fairness of the law that was taught. Our job was just to learn it, get it into our heads, and parrot it off when we got to the exam questions. And so what I did was basically something that derived from the agreement at Murray Gleeson's suggestion to share lecture notes with him and to, in my case, provide a summary of the course of my answer and colour and headings and all the other things that subsequently in my life on the High Court of Australia and on the Court of Appeal of New South Wales I used, because the job of the law, at least in exams, is communication. The job of the law in practice is communication. And that was basically what I endeavoured to do. Our lives went different ways. When we went after the law degree, but then came together again when we met again in the Court of Appeal of New South Wales and in the High Court of Australia. And that teaches you the lesson that you can never be quite sure of where the young man or young woman sitting next to you in a law course is going to end up. That's a reason why you should make as many friends as you can at law school, because years later they may be people who interact with your career. It's true, I think, looking back, that most of the people I got to know at school and at university remain friends years and years later, decades later, and not all of them, but some of them become close friends and close professional colleagues, and that is a feature of life in the law. So I don't know if my technique will have any relevance at all in the age of computers and of keyboards and of the internet and of the other sources of law, which is so much wider today than it was in my time. Getting up-to-date law was a menace and a problem back in the 1950s, 60s and 70s. But I do think that if you can conceptualize the study, if you can get the grand ideas into your head, then everything else will basically follow. And when I sat in the Court of Appeal as president, or in the High Court of Australia as a justice, as I was listening to the submissions of counsel, I was still at it. I was still drafting the tree diagram relevant to the case. And in his biography of me, A.J. Brown, Professor A.J. Brown of Griffith Law School, took a photograph of one of those tree diagrams, and it's there in a photographic plate in his book. And it would give those who are interested an idea of how to do it. Conceptualization is very important in the law if you're not just going to wander all over the shop and throw a lot of data at people. You have to analyze, you have to conceptualize and bring it all together, either in a court of appeal or in the High Court or in the local magistrates court or just across the desk with a client seeking to get solutions to the problems they bring to you. So I extend the very best of wishes to the students of VLS and any other students who come to watch this program. And I hope that your life in the law will be rewarding, not just in the financial sense, but in the sense of solving problems and puzzles for clients and litigants and contributing to the rule of law for Australia and its citizens.
So, Michael, thank you very much for that wonderful talk. One question I had was whether those tree diagrams that you were mentioning, particularly from the High Court, were and are available, because I think that's a wonderful resource.
They would be available depending on what the time limit is for access to judges' papers. And the recent decision of the High Court in the case concerning the royal papers rather suggests that something that is done in the course of one's duty as a Commonwealth officer will ultimately be available to the public. It was Professor A.J. Brown, when he was writing a biography of me, which is now published, that saw these tree diagrams, and he was fascinated by them. And he immediately whipped out a camera and started taking photographs of them. And in his biography, Michael Kirby, Principles and Pragmatism, there is a photo of I think 2 tree diagrams. One of them is in the case of Thomas and Mowbray, a case concerning anti-terrorism and security legislation. So there is an illustration of that in that photograph, and there are plenty of examples of it in the papers that I deposited with the High Court and the National Archives.
And I noticed from your book, A Private Life, Fragments, Memories and Friends, that art, in fact, was an important part of, I think, your schooling. And I recall you mentioning that Mr. Gorringe, one of your teachers, was very much encouraging you to do art. And I think one of the things I read about was you did a fantastic diagram of a future Sydney. And it was on an old-fashioned chalkboard. And then one day the cleaners came in and someone had wiped it off, but it could have been your alternative career in architectural town planning.
It broke my heart when the cleaner removed it. But it's interesting that I drew elevated highways, which were not a feature of how things were back in. This was at school. This was in the 1940s. So we're really talking of ancient history here. But we were encouraged in art, but not at all as much as a child at school in the Netherlands. In the Netherlands, my partner tells me, art is, of course, at the core of their culture. The Rijksmuseum has hundreds of Rembrandts and other great artistic works, and school children are taken repeatedly to the great museums of the Netherlands and taught about the theory that the face has two sides, and one is the kind side, and one is the hard side. We're seeing Mr. Putin's hard side at the moment, but it's something they learned much more systematically than I did. Mr. Gorringe was an ex-serviceman, as many of the teachers were in our schools in the 1940s. And one thing he did teach me was the Universal Declaration of Human Rights, which had just been adopted by the General Assembly of the United Nations. And that was a very important gift. It shouldn't be thought that the brave men and women who fought in the Australian military loved war. They didn't love war. Mr. Gorringe didn't love war. And he said, the only way we're going to prevent more wars is if we all learn and practice the Universal Declaration of Human Rights. That had a big effect on me then, and it is an effect that has lasted.
Fantastic. And in terms of studying law alongside arts, did you find arts gave you a creative or imaginative realm that law wasn't giving you, or how did you find the arts with the law combined and interacted, fed off each other?
Well, because of my marks in the leaving certificate, it was, as the HSC was called in those days, I won a bursary, and that was on top of the Commonwealth Scholarship. And therefore, doing the BALLB course just seemed a natural thing to do. I cannot really say that learning about 7 centuries of sonnets in the English course, or learning about Rorschach tests and psychological analysis in the psychology course, or learning about the ancient Greek philosophers in the philosophy course. I don't really think that had a practical and immediate impact on the law course and on my understanding of law. But it was part of the idea of law being an example of the liberal arts tradition. And therefore, when I went down from the university, which is on the main campus in Sydney, and started in the law course, which was in a horrible building in the central business district of Phillip Street in Sydney, I just saw my university days as days of cramming. And that was why my salvation was to conceptualize. I don't think lawyers do that enough. And I had really learned that at school. And I then learned to practice it in my arts course and in my law course. But I can't really say that my arts part of my arts law combined degree had a big impact on my law course. The biggest impact in my case was the teaching by Professor Julius Stone, who was a very great teacher at the Sydney Law School in those days, who taught us the international law and the principles of jurisprudence or legal values. Interestingly, much of the international law course was on the Korean War and the vote in the Security Council when the Soviet Union, as it then was, walked out because of the refusal of the United States to agree to the People's Republic of China substituting for the China seat in the Security Council. And many of the issues that have arisen in debate in recent days about the war in Ukraine are now being repeated from back in the 1960s and 70s. The world goes on, but it does tend to reinvent the wheel constantly. And both in that time and today, international law had a very vivid and immediate and important impact on living as a human being in the world.
And that and really tying into that idea of grand concept that you talked about.
Yes.
So, and I think another challenge for law students that you found and overcame was this brilliant one of a partnership in fact and a friendship with Murray Gleeson. And I think one of the things students I think have found challenging with COVID, particularly in the last 2 years, was that idea of making connections with their colleagues and classmates. But I think your talk really brought home that idea of collegiality, partnership, working together, and two heads are always better than one, and bringing those skills together was a wonderful example. So thank you very much for sharing that, Michael.
It's my pleasure and duty.
Fantastic. Thank you again so much.